In this voice thread, we are going to return to the Fifth Amendment again, but this time we're going to look at the cases related to self-incrimination. So everybody is familiar with the idea of, quote unquote, taking the fifth in the courtroom, but what sorts of issues extend beyond the courtroom? So we're going to look at some cases dealing with the steps that lead up to trial, including arrest and interrogation. In the last voice thread, we looked at the double jeopardy clause and the takings clause of the Fifth Amendment. In this one, we are going to look at the part that is highlighted here on the slide in red, where it says that no person shall be compelled in any criminal case to be a witness against himself. Well, what does it mean to be a witness against yourself? As I mentioned in the last slide, this conjures images of sitting in a courtroom and perhaps being questioned. But ultimately, the issue of being compelled to be a witness against oneself has to do with the voluntariness of confessing to wrongdoing and then subjecting oneself to punishment. One of the key ideas in Fifth Amendment jurisprudence is coercion, right? So toward the end of this lecture, we're going to revisit this in the context of Miranda versus Arizona, where it's phrased sort of as like the inverse, as the voluntariness doctrine. But really the evil that this right is trying to protect citizens from is coercion, right? So being coerced either psychologically or by physical violence into confessing to a crime that the person did not intend to confess to. To briefly recap, the idea of self-incrimination involves two key elements. So number one, testimonial evidence is given that incriminates the person providing it. Number two, that evidence is compelled by the government. So this is pretty easy to understand if we sort of imagine our clear image of, like, quote unquote, taking the fifth, right, to avoid self-incrimination. We picture this taking place at trial, right? So questions being asked, someone generally refusing to answer them. But what about before the trial stage is reached? So this is something that the Warren Court grappled with in the early to mid 20th century. So they addressed a number of cases having to do with interrogations. So your textbook gives some detail about a few of the early cases that are important here, but I'm just going to sort of mention them here. So the first one actually takes place before the beginning of the Warren Court era. This was during the time of Chief Justice Hughes, and that is Brown versus Mississippi. So this case was argued in 1936, but it had to do with events that took place in 1934 in Mississippi. So obviously this is the Jim Crow South. So our expectations for how African-American defendants might be treated, especially when the crime, in this case a murder, had a white victim, right? We might imagine how this proceeded. So Brown versus Mississippi is a really appalling and upsetting case. I'm not going to go into all of the facts of it here, but a couple of things to consider. First of all, there was a confession, but that confession was extracted using physical violence and psychological torture, humiliation, right? So methods that no reasonable person would not consider coercive. So when this was ultimately appealed to the court did reverse the convictions. And this was a decision that was made unanimously. So as discussed before, when the court hands down a unanimous decision, they are sending a message, right, that this is something that's important. So Chief Justice Charles Evans Hughes wrote the opinion, and in it he completely rejects the idea that any kind of coerced or non-voluntary confession or evidence can be treated as legitimate evidence in a trial. So one of the quotes from his opinion is, "It would be difficult to conceive of methods more revolting to the sense of justice than those taken to procure the confessions of these petitioners." So that was in 1936. There have been other important cases since then. So for instance, 1959 Spano versus New York. And in that case, the court rejected the use of psychological torture specifically. And this is important because, since the 1930s, there was a clear rejection of physical coercion. But here the court begins to recognize that certain things that might be described as quote unquote interrogation techniques, in fact, amount themselves to psychological torture or to coercion. Okay, so let's take a moment at this point to touch on the Miranda warning, because this is, of course, where all of this is going. So when I teach civil liberties, I like at the beginning of the class to ask people what they know about constitutional law. Often many of them will say that they don't know anything about constitutional law. And then I will ask them to recite the Miranda warning. And I would bet that right now it's running through your head already, right? So we all know this from Law and Order. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be provided for you. Do you understand these rights I have just read to you? With these rights in mind, do you wish to speak to me? So this very famous warning comes from perhaps the most influential self-incrimination case, which is Miranda versus Arizona. So there are a number of important elements here. So there's a different phrasing listed below, right? And this one might arguably be a bit more legally or constitutionally useful, because not only does it point out that the person who's under arrest have the right to an attorney, but that they also have the right to have that attorney present while they are being interrogated, right? And that they have the right to consult that attorney before they speak to the police. Well, why are we talking about attorneys if we're concerned about self-incrimination? Aren't these Sixth Amendment issues, right? So we'll talk about the Sixth Amendment next, which has to do a lot with fair trials, representation, etc. Well, attorneys are important because they are trained in not only the law, but in sort of like how to resist the kinds of pressure tactics that might be used in police interrogation. Now, I don't know about you, but most of us probably aren't very well prepared psychologically to stand up to hours and hours and hours of interrogation with a trained interrogator. So this becomes one of the central issues in a 1964 case called Escobedo v. Illinois. So one thing I want to point out here, and this came up also in the Spano case, it comes up in a lot of self-incrimination cases, is that some people are more vulnerable than others when they're in the interrogation room, right? So people who are young, people who perhaps have a limited degree of education, who may have cognitive disabilities, mental illness, right? So all of these sorts of things contribute to how vulnerable a person is in the face of police interrogation. And when I say vulnerable, what I mean is that they are vulnerable to being coerced, right? So to giving a confession or speaking or giving evidence against themselves in a way that isn't meaningfully voluntary. We'll turn now to Escobedo v. Illinois to tie all of these threads together. So the facts of the Escobedo case are a little bit confusing because they involve more than one interrogation. So what happened was that police arrested Danny Escobedo, who was 22 at the time, on suspicion of the murder of his brother-in-law. So Escobedo, before he was interrogated by the police, was able to contact his attorney, and his attorney advised him not to speak to the police, not to give them any information. So at that point, the police released him. However, later, one of his friends gave evidence that Escobedo was involved in the murder, so the police went and picked Escobedo up again, right? So this was 10 days later. The police arrested him and his sister, brought them both into the police station for questioning. So this is where things, again, get a little bit complicated. So before the pair were actually brought to the police station and put in an interrogation room. They were put in the back seat of a police car. So they're sitting in the back seat of the police car as the police officer is transporting them to the station. One of them explained that their friend had given this information, right? That there was a confidential informant involved, and that the police knew everything, so Escobedo may as well confess. So at this point, Escobedo declined to comment, and ultimately he arrived at the station with the police officers, where they again began asking him questions, and he again declined to comment, and then asked specifically for his attorney. He was told that the attorney would not be contacted, right? That the police would not do this. He would not be permitted to speak to his attorney. So even without being contacted directly by Escobedo, his attorney turns up at the police station and asks over and over again to see his client. He is told over and over again that he can't. So Escobedo ultimately is held for 14 and a half hours under heavy interrogation. And finally, at the end of this, he confesses, essentially, right? So he gives a statement saying that, implicating himself in the murder. So when this goes to trial, the police want to enter that confession as evidence. Ultimately, Escobedo and the confidential informant were convicted of the crime. So Escobedo appealed, arguing that his right to counsel was violated when he was brought to the police station, and when he asked for his lawyer, the lawyer wasn't permitted to see him. So the question that comes before the court was this: does the refusal by police to allow the petitioner, Escobedo, to consult with his lawyer during interrogation constitute a denial of the assistance of counsel in violation of the Sixth Amendment? Okay. Again, why are we talking about the Sixth Amendment in the section on self-incrimination? I will get to this in just a moment. Just stick with me. So a year prior to this, the court had decided what is considered a very important case in what's referred to as, quote unquote, the rights revolution, which is the expansion of civil liberties, mostly under the Warren Court, that took place throughout the 20th century. And that case was Gideon versus Wainwright. So in Gideon versus Wainwright, which was a Sixth Amendment case, the court found that an indigent criminal defendant had a right to counsel at trial. Okay, so what are the parallels here? Well, in Gideon versus Wainwright, there was a vulnerable person involved. So there are some parallels here with the Escobedo case, right? So remember, Danny Escobedo was very young. He was 22 years old, and he was also a minority, right? So he was in a vulnerable position during the interrogation. So that vulnerability to coercion ends up being very important in the way the court decides this case. So that is one important point, right? So there's the shadow of Gideon versus Wainwright here. And then in addition to that, the court took a look at the events leading up to Escobedo's conviction, and they said that at the point when Escobedo asked for his attorney and was denied, at that point, that investigation ceased to be a sort of like general investigation of the crime, and turned, or of an unsolved crime, sorry, and turned into specifically an interrogation of a particular individual, right? And that was Danny Escobedo. So again, what the court is looking for is how voluntary was the confession? Well, when they look at all of these circumstances together, Escobedo's vulnerability, the fact that he had asked for his lawyer, right? And then at the point when that was denied, he really became the focus of the police efforts. So in addition to this, even though he wasn't formally charged, he was being held in custody. He didn't have good reasons to believe that he was free to go. So all of these circumstances begin to add up to something looking an awful lot like coercion. So as I said, ultimately, Escobedo was decided at the time on Sixth Amendment grounds, But 2 years later, when the court revisited the question of self-incrimination in Miranda versus Arizona, Escobedo versus Illinois was effectively superseded. And the question of whether or not counsel ought to be present for interrogation then becomes not necessarily just a Sixth Amendment issue, but also a Fifth Amendment issue, right? Because counsel is important because they are that shield between the vulnerable individual and the potentially coercive circumstances of interrogation. So 2 years later, the court revisits the question of self-incrimination during interrogation with a case that is in some ways quite similar to the Escobedo case and in others very different. And so this is Miranda versus Arizona, decided in 1966. So the ways in which it was similar to Escobedo versus Illinois is that in this case, we have, again, a very young man, right? So Ernesto Miranda was 23 years old. Now, in addition to this, he was also a minority, right? So he was Hispanic. He lived in Phoenix, Arizona, where there was a large Hispanic population. But again, he was a minority. So in addition to that, he was also indigent, which means that he had very limited resources, right? So this isn't somebody who could afford to hire an expensive private lawyer. And also he had very limited education. So in some ways, Miranda is similar to Escobedo, in others he isn't. But in both cases, we are looking at defendants who have certain vulnerabilities. Again, vulnerabilities to being coerced in an interrogation situation. So at this point, the court really is increasingly concerned about how, like, quote unquote, inherently coercive police interrogation might be. Right? So in this period in Escobedo and Miranda, the court is beginning to acknowledge that under the onslaught of some of these really, really aggressive interrogation techniques, and when those interrogations can last hours and hours and hours, many people who are innocent are likely to crack, right? Just simply from the pressure. And so the court has these concerns in mind as they approach the Miranda case. Now, one of the big differences between Miranda and Escobedo is that at no point during his interrogation did Ernesto Miranda request an attorney. So this is an important point. So after 2 hours of questioning, Miranda confessed. There was no evidence of, physical violence or psychological torture. But the question here was whether or not Miranda actually had a meaningful opportunity to invoke that right to counsel and to sort of protect himself in that interrogation. So Earl Warren himself actually wrote the decision in Miranda versus Arizona. And so kind of the thrust of his decision, I think, it makes sort of like common sense, which is to say, having these important civil liberties really doesn't do very much to protect us if we are not aware of them, right? And so in this case, Ernesto Miranda, again, someone with limited education, was not aware of his Fifth Amendment rights. So Warren argues that this is sufficient to bring questions of coercion into the picture. So as you can see on the slide, I've excerpted some of Warren's decision. And so this is what he outlines. Very specifically, he gives guidelines, right? So when I quote, "The person in custody must, prior to interrogation, be clearly informed that he has the right to remain silent and that anything he says will be used against him in court. He must be clearly informed that he has the right to consult with a lawyer and to have the lawyer with him during interrogation, and that if he is indigent, a lawyer will be appointed to represent him." So essentially, Warren is arguing that people need like a sort of like brief primer in their Fifth Amendment rights before they are taken into police custody, because we can't necessarily count on them being aware of even having these rights, much less the sort of like fine points of how to exercise them. And because, once you are in police custody, there is again that position of vulnerability to coercion. So Warren lays this out quite clearly, what has to be included in the Miranda warning and why. So this is a very strong statement, right? So Warren is saying that interrogations are not legitimate, right, for evidential purposes if this warning isn't given in the first place. So there's a sort of like parallel between the Miranda warning and maybe the exclusionary rule here, right? So these are requirements that are in place to kind of deter police from abusing people who are under investigation. So as you probably are aware from various police procedurals, questioning must cease when the right to an attorney is invoked. So, right, the set of rights established and outlined here in Miranda are very robust. Now, that said, there are some exceptions to the requirements for the Miranda warning, right? So again, as you're looking at these, so there's actually a very useful table in your textbook at pages 490 to 491 that I strongly encourage you to look at in some detail. But again, the sort of central idea that is returned to time and time again here is voluntariness, right? So is the statement being given voluntarily? Is coercion present? Well, in assessing that, we have to look at a few different things, right? So there's the vulnerability of the person involved, but then there's also the question of whether or not they are in custody, right? So one of the questions that arises in many of these cases is, when does the interrogation begin, right? So if a police officer sort of approaches, somebody and that person is nervous and just sort of says something, right, like spontaneously, is that an interrogation? Generally speaking, the interrogation is thought to begin when the person is taken into custody. Well, when are they taken into custody, right? Is it the point at which they arrive at the police station? Is it when they're cuffed? So take a look at those cases on 490 to 491, and you'll see some of those specifics worked out. Generally speaking, when you're assessing whether or not someone is in custody for Fifth Amendment purposes, the question is whether or not they are free to leave. And not only whether they are free to leave, but whether they believe that they are free to leave. So for that, I would actually like to draw your attention to some of the cases involving prison inmates, right? So people who are like literally in custody, right? Like all the time. So take a look specifically at House versus Field from 2012. So this is a case involving a prisoner, right? So this is someone who was incarcerated. They were like literally, as I said, in custody. So two armed sheriff's deputies were questioning the prisoner regarding a crime that was unrelated to the crime for which the person was incarcerated. And in the course of this conversation or this questioning, the prisoner confessed. But they hadn't been given their Miranda warnings. So the question arose whether or not this was a problem under the Fifth Amendment. So what the court found in this case was that because the prisoner was informed that they could terminate the interview at any point, it was voluntary, right? So that knowledge that they could leave and return to their cell and end the conversation was enough to assure the prisoner that they were not, quote unquote, in custody. So I guess I would be interested in hearing either on the discussion board or in discussion elsewhere, what you all think about that, right? Like, so is that voluntary enough? When someone is in custody, is there really any point at which they feel free to leave an interaction with an officer in a meaningful sense? I would also like to draw your attention specifically to the 1994 case, Davis versus United States. So this deals with what it means to actually invoke the right to have an attorney present during interrogation. And it deals with an ambiguous invocation of the right. So in the midst of an interrogation that had been sort of like ongoing, the suspect, who had incidentally been properly Mirandized, made the comment, maybe I should talk to a lawyer. But after this, the questioning continued, and statements were made that were incriminating. And so the question was raised afterwards whether or not this was a violation of his Miranda rights, right? Does that qualify as asking for an attorney? And in that case, the court found that, in fact, it did not, right? That Miranda doesn't necessarily require the police to stop questioning somebody when they have made like when they have made an ambiguous reference to an attorney, when they have not sort of in a straightforward way said, I want my attorney. So yeah, take a look at the ways in which Miranda has been narrowed since its decision. So I'm going to just touch briefly on Missouri versus Siebert, which is a 2004 case your book considers in some detail. But there are a couple of things I'd like to point out here. So one of them is that this takes place in 2004, right? So this is a world in which people are very aware of the Miranda warning, right? At this point, it's in all the police procedurals. We've all seen it on TV. Most of us have it memorized. And this raises a question whether or not that should sort of like change how the court approaches self-incrimination, right? It really does change that vulnerability piece. You don't necessarily have very many people walking around out there anymore who don't know their Fifth Amendment rights. So this is in many ways a very sad case, right? The facts deal with the death of a 12-year-old child. Patrice Siebert, his mother, is brought into the police station and questioned. But really, this case hinges on this two-step, quote-unquote, interrogation technique that the court ultimately argues was designed to subvert the Miranda warning, right? So again, 2004, this is a world in which people know their Miranda rights, but the police, right, and interrogators have also begun to adjust their methods, right, to respond to this new, or maybe not new, but this now established widespread awareness of Miranda rights. So one of those adaptations is what the police officer in this case refers to as, so his name is Richard Hanrahan. He refers to what this quote-unquote interrogation technique, wherein the suspect is brought into the police station. There's a conversation between the interrogator and the suspect. And during that conversation, which takes place before the suspect has been given their Miranda warning, the suspect is sort of encouraged to make incriminating statements. Then at that point, the police officer says, gives them the Miranda warning. And then they continue the conversation, during which time the interrogator gets the suspect to repeat the incriminating statements. So the court looked at this and said, this, like, quote unquote, interrogation technique is actually just like a sort of conscious attempt to get around the spirit of the Miranda warning, right? So one of the things they point to here is that there's no substantial break in time, right? This isn't like there was one interview, then there's a period of time during which the person is turned loose, and then a new interview begins, starting with the Miranda warning. No, right? This is essentially one interview wherein the person is encouraged to incriminate themselves and then is given the Miranda warning and then is encouraged to repeat those incriminating statements. So the court rejected that interrogation technique, right? So they found that, in fact, Patrice Siebert's Fifth Amendment rights had been violated. And so this is treated, among other things, as a reaffirmation of Miranda. So, as I've said before, there is no such thing as settled law, right? Once a decision is made, it can always be altered, reversed, adjusted through, one of these quote unquote concurrences that's actually more like a dissent. So Miranda has been treated since the 1960s as this sort of like rock, right? So it's a very strong protection for criminal suspects or like people who are subject to police interrogation. And as I said, in 2004, the Siebert case reaffirmed Miranda. But that doesn't mean that Miranda hasn't been weakened in other ways. And so there's this 2010 case I'd like to draw your attention to called Berghuis v. Tompkins. And I want to draw your attention to it. We're not going to talk about it in a lot of detail. Your book doesn't really discuss it. But one of the things that the court considered in this case was that now the awareness of Miranda rights is really widespread. And so one of the questions that raises is how vulnerable really are these people being interrogated? And also then when the person being interrogated maybe, sort of fails to invoke their right to counsel in a very assertive and direct way, because that awareness of the Miranda rights is so widespread, then perhaps the court shouldn't extend them too much sympathy, right? So this was another case in which the right to counsel was sort of ambiguously invoked. And then there were statements made, right, after that right to counsel was ambiguously invoked, obviously because of the way that they asked for counsel. They were not, their counsel wasn't brought into the room. And so in this case, the person, Mr. Tompkins, was convicted on the basis of the statements that he made. So he argued that his Miranda rights had been violated. And in this case, the court did not find in his favor for these reasons, right? That the way that he asked for counsel was not unambiguous, and that essentially he should have known better because awareness of Miranda rights is now so widespread. So again, I'm going to ask you to kind of reflect on this question. Are these considerations that the court should be treating as this important, right? So how important is it that our awareness of our Miranda rights is widespread? Does it really significantly make us less vulnerable when we're being interrogated? Would you still consider those statements made under those circumstances as being voluntary, right? So in this case, the court did, right? So this was somebody who was in police custody. Isn't detention fundamentally intimidating, right? Isn't it fundamentally coercive or compulsory? So that wraps up our exploration of the Fifth Amendment. Next, we will move to the Sixth Amendment and fair trials. So we're going to look at a number of questions. First of all, right, what constitutes effective or ineffective assistance of counsel? We'll also look at what goes on in the courtroom, right? But also what goes on in the run-up to the trial itself. How important is the makeup of the jury? Who's chosen? Who is struck? What constitutes legitimate reasons for striking a juror, right? So there are challenges with reason, and there are challenges for which no reason has to be given. How important are jury instructions and deliberation procedures? So we're going to be talking a lot about sort of like basic fairness, the idea behind a jury trial being, well, actually, I want to raise that question. Like, what is the idea behind putting people in front of a jury? We obviously want certain things. We want the jury, juries fundamentally are supposed to find facts. That's what they're supposed to be establishing. So we want juries to be competent in establishing facts, but we also want other things from them, right? We want them, for instance, to legitimate the criminal justice system. We want to feel like they are trustworthy. But how do we feel that they're trustworthy? Do we want them to be representative of the general makeup of the population? Do we want them to have something in common with the person that they are set up to judge? So we're gonna look at all of these questions, and then some related issues as well, such as what constitutes a speedy trial and what doesn't, right? Like if you know anything about the current American criminal justice system, you know that waits for trials tend to be like quite long, like several months to a year. So we're going to get into all of those things in the next section on the Sixth Amendment.